A federal judge just revoked Donald Trump's bail and ordered him into custody pending trial. Judge Tanya Chutkan issued the extraordinary ruling this morning after prosecutors presented evidence that Trump violated his release conditions by attempting to intimidate witnesses through social media posts and public statements targeting individuals expected to testify against him. And this isn't some temporary detention for a bail hearing that will be reversed on appeal. This is a federal judge finding that Trump poses such a danger to the integrity of judicial proceedings that he must be held in pretrial detention until his criminal trial concludes. When a federal judge revokes bail for a former president and orders U.S. Marshals to take him into custody, you know, the judicial system just crossed a threshold that will reshape American political history. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this unprecedented judicial action? Prosecutors filed an emergency motion on January 18th, arguing that Trump had systematically violated the conditions of his release by posting over 40 threatening messages targeting witnesses, court personnel, and prosecutors involved in his federal election interference case. The motion included detailed documentation showing Trump's posts contained specific identifying information about witnesses, threatening language suggesting they would face consequences for testifying, and explicit calls for his supporters to take action against those cooperating with prosecutors. Judge Chutkan held an emergency hearing yesterday where she reviewed the evidence and concluded that Trump's conduct demonstrated a clear and present danger to witness safety and the administration of justice that could not be addressed through modified bail conditions. And believe me, when a federal judge determines that a former president cannot be trusted to follow court orders and must be detained pending trial, the entire foundation of his legal and political strategy just collapsed. Here's the full picture of what's been unfolding. Tensions over Trump's public statements have been escalating for months, with prosecutors filing multiple motions seeking stricter limitations on his commentary about the case. But everything reached a crisis point on January 15th when Trump posted a message on Truth Social that federal prosecutors characterized as a direct threat against a cooperating witness. The post included the witness's initials, referenced their expected testimony, and stated that people who betray their country face serious consequences throughout history. Judge Chutkan had previously issued a limited gag order restricting Trump's ability to make statements about witnesses, prosecutors, and court staff. Trump's attorneys successfully appealed portions of that order, arguing it violated his First Amendment rights as a presidential candidate. However, Chutkan maintained restrictions specifically prohibiting statements that could reasonably be interpreted as threatening or intimidating witnesses. The January 15th post appeared to violate those restrictions directly. Prosecutors moved swiftly. On January 16th, they filed a motion documenting not just the January 15th post, but a pattern of escalating violations over the previous 2 weeks. The filing included screenshots of 43 separate social media posts and transcripts of 3 campaign rally speeches where Trump made statements prosecutors argued were designed to intimidate witnesses and prejudice potential jurors. The motion requested an emergency hearing and asked Judge Chutkan to consider revoking Trump's release entirely. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Chutkan convened the emergency hearing yesterday morning at 9:00 a.m. in her Washington, D.C. courtroom, legal observers immediately recognized the gravity of the situation. Federal judges rarely hold emergency bail revocation hearings, and such proceedings involving a former president were completely unprecedented. The hearing lasted over 4 hours, with prosecutors methodically presenting evidence of Trump's alleged violations, while his defense team argued the statements constituted protected political speech. Here's what multiple sources present at the hearing say happened. Assistant U.S. Attorney Molly Gaston began by walking Judge Chutkan through a timeline of Trump's posts over the previous 14 days. Gaston presented evidence showing that within hours of a witness's identity being disclosed in court filings, Trump would post messages referring to that witness using identifiable characteristics and suggesting they were part of a conspiracy against him. The prosecution argued this pattern demonstrated deliberate witness intimidation. The most dramatic moment came when prosecutors presented testimony from 2 witnesses who had received threatening messages from Trump supporters after being referenced in his posts. One witness, a former White House aide, testified via secure video link that after Trump posted about presidential advisors who turned traitor, she received over 300 threatening messages within 24 hours, including specific death threats that required FBI protection. Another witness, a state election official, testified that Trump's supporters showed up at his home after Trump posted about corrupt state officials who changed vote counts. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. Trump's defense attorney, John Lauro, argued strenuously that Trump's statements constituted political speech protected by the First Amendment. Lauro contended that as a presidential candidate, Trump had the right to defend himself publicly against what he characterized as politically motivated prosecutions. Judge Chutkan repeatedly interrupted, asking Lauro to address the specific evidence of witnesses receiving threats immediately after Trump's posts. The turning point came when Judge Chutkan asked Lauro directly whether Trump understood that his release was conditioned on not intimidating witnesses. Lauro responded that Trump believed his statements fell within permissible political commentary. Judge Chutkan's response, according to multiple reporters in the courtroom, was delivered in a tone described as controlled fury. She stated that Trump's subjective belief about what constitutes acceptable commentary is irrelevant when his actions demonstrably result in witnesses receiving death threats and requiring federal protection. That's when the constitutional crisis became unavoidable. Judge Chutkan announced from the bench that she was revoking Trump's release and ordering him remanded to custody pending trial. The courtroom fell into stunned silence. Reporters present described the moment as surreal, watching U.S. Marshals approach the defense table as Trump sat rigid and his attorneys immediately began arguing for a stay of the order pending appeal. Judge Chutkan denied the stay request, stating that the danger Trump poses to witnesses and the judicial process is immediate and cannot await appellate review. This isn't the first time courts have detained high-profile defendants pending trial for bail violations. Think back to 2019 when Paul Manafort, Trump's former campaign chairman, had his bail revoked after prosecutors proved he attempted to tamper with witnesses while on release. The judge in that case concluded Manafort posed too great a risk to witness safety to remain free. Manafort spent months in detention before his trial and eventual conviction. Then consider 2023's case involving former crypto executive Sam Bankman-Fried. He initially was released on bail, but had that revoked when prosecutors showed he had attempted to contact witnesses and intimidate them through intermediaries. The judge found that no bail conditions could adequately protect witnesses from someone with Bankman-Fried's resources and determination to obstruct justice. He remained in detention through his trial and conviction. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. More recently, dozens of January 6th defendants have had their pretrial release revoked when prosecutors demonstrated they violated release conditions by continuing to engage with extremist groups or making threatening statements about witnesses. Federal judges have consistently held that defendants who demonstrate they cannot be trusted to follow court orders must be detained regardless of their prior status or resources. Now, however, the situation involves a former president of the United States. Trump's attorneys argued that detaining a major party presidential candidate raises unprecedented First Amendment and political concerns. But Judge Chutkan's ruling makes clear that constitutional protections do not extend to witness intimidation regardless of the defendant's political status. The pattern is undeniable. When defendants use their platform and resources to threaten witnesses and undermine judicial proceedings, courts will revoke their freedom to protect the integrity of the justice system. So what specifically led Judge Chutkan to take this extraordinary step? According to the written order she issued immediately after the hearing, Trump's conduct over the past 2 weeks demonstrated a deliberate and systematic effort to intimidate witnesses through public statements designed to identify them to his supporters and suggests they should face consequences for cooperating with prosecutors. The order cites specific examples where Trump's posts were followed within hours by witnesses receiving death threats requiring FBI intervention. Judge Chutkan's order emphasizes that she previously warned Trump multiple times that his release was conditional on respecting witness safety and the judicial process. The order states that Trump's continued violations despite repeated warnings demonstrate that no modified bail conditions would be sufficient to protect witnesses and ensure fair proceedings. Sources familiar with the order say Chutkan specifically rejected arguments that Trump's status as a presidential candidate warranted special treatment, writing that the rule of law requires equal application regardless of a defendant's political prominence. Here's the kicker. The order directs U.S. Marshals to transport Trump to the Federal Correctional Institution in Alexandria, Virginia, where he will be held in a secure unit pending his trial, scheduled to begin March 4th. The facility houses pre-trial defendants in federal cases and includes secure units for high-profile detainees. Legal experts reviewing the order noted that Chutkan specified Trump would not be held in general population, but rather in conditions appropriate for his security needs and former presidential status. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone concerned about judicial independence and witness protection. This isn't just about one defendant violating bail conditions. If individuals facing criminal charges can use their public platforms to identify and threaten witnesses without facing detention, the entire witness protection system and the ability of courts to ensure fair trials collapses. Once that precedent is established, wealthy and prominent defendants could effectively intimidate their way out of accountability. This puts Trump's presidential campaign in an impossible situation. On one side, he now faces the reality of being detained in a federal facility while running for president. Campaign events will be impossible. Fundraising will occur from detention. His ability to participate in debates, give speeches, or conduct normal campaign activities effectively ends. On the other side, he must maintain claims that this detention is political persecution, while a federal judge has documented 43 specific instances of conduct that violated his release conditions. And here's the political and legal crisis this creates. There's no immediate escape. Either Trump's attorneys convince an appellate court to overturn Judge Chutkan's detention order, which legal experts say is extremely unlikely given the detailed factual findings of witness intimidation, or Trump remains in custody through his trial. His argument that these prosecutions are politically motivated witch hunts becomes harder to sustain when the detention results from his own documented conduct threatening witnesses. Legal analysts and former federal judges are calling this one of the most significant bail revocation rulings in American legal history. Former federal judge Nancy Gertner, now a Harvard law professor, told CNN that Judge Chutkan's decision reflects standard legal principles applied to an extraordinary defendant. Gertner explained that bail revocation for witness intimidation is routine in federal court when prosecutors present clear evidence of threats. The unprecedented aspect is not the legal reasoning, but rather the defendant's identity as a former president. Do me a favor and slam that like button because it genuinely helps this video reach more people. Former federal prosecutor Renato Mariotti told MSNBC that Trump's detention demonstrates the principle that no defendant is above the law or the conditions of their release. Mariotti emphasized that federal judges have broad discretion to revoke bail when defendants violate release conditions, and appellate courts rarely overturn such decisions when supported by factual findings of witness intimidation. Even Alan Dershowitz, a constitutional law scholar who has defended Trump on legal issues, acknowledged in a Wall Street Journal interview that Judge Chutkan's ruling appears legally defensible if the factual record supports findings of witness intimidation. Dershowitz noted that while he questions whether some of Trump's statements cross the line into intimidation, courts generally defer to trial judges' assessments of witness safety concerns. So let's break down the immediate implications. First, Trump will be transported to federal detention within hours of the ruling. U.S. Marshals have jurisdiction to execute Judge Chutkan's order immediately. Trump will undergo standard intake procedures at the Alexandria facility, including medical screening, property inventory, and assignment to a detention unit. Legal experts note that, as a former president with Secret Service protection, Trump will likely be housed in a secure unit separated from other detainees. Second, Trump's campaign operations face unprecedented disruption. All campaign events scheduled through the trial date are effectively canceled. Trump cannot participate in debates, rallies, or public appearances. His campaign team will need to pivot to a strategy built around surrogate appearances and media coverage of Trump's detention and trial. Polling data suggests that images of Trump in detention could significantly impact public opinion, though whether that impact helps or hurts him remains uncertain. Third, Trump's legal team will immediately appeal Judge Chutkan's detention order to the D.C. Circuit Court of Appeals. However, appellate courts apply an abuse of discretion standard, meaning they will overturn the detention order only if Judge Chutkan's factual findings are clearly erroneous or her legal conclusions represent a significant error. Given the detailed record of Trump's statements and the testimony about threats witnesses received, legal experts consider reversal unlikely. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political ramifications, this detention addresses fundamental questions about whether the judicial system can function when defendants use their platforms to intimidate witnesses. Witnesses testify under oath at great personal risk when they provide evidence in criminal cases. That testimony serves as the foundation of the adversarial justice system that defines American criminal law. If defendants can identify witnesses publicly and encourage their supporters to threaten those witnesses without facing detention, the witness protection system becomes meaningless. Witnesses will refuse to testify rather than face death threats and violence. Criminal prosecutions will collapse when evidence cannot be presented because witnesses fear for their safety. The ability of courts to conduct fair trials depends on protecting witnesses from intimidation. This situation has created absolute chaos within Trump's campaign and legal team. Multiple sources report emergency strategy sessions occurring throughout yesterday and today to determine how to respond to detention that removes Trump from the campaign trail for potentially months. Some advisors reportedly argued that the detention would galvanize Trump's base and prove his claims of political persecution. Others expressed alarm that images of Trump in detention would alienate swing voters and independents. The campaign faces impossible messaging challenges. Reports indicate internal debates over whether to emphasize Trump's detention as martyrdom or attempt to minimize discussion of his circumstances. Trump's social media team faces the reality that Trump cannot post directly while detained, fundamentally changing his communication strategy. Campaign managers must reimagine how to maintain momentum when their candidate cannot appear publicly. Meanwhile, Trump's core supporters are reacting with fury to what they characterize as judicial tyranny and political imprisonment. Social media platforms show widespread calls to protest Trump's detention, demands that Republicans in Congress intervene, and conspiracy theories claiming the entire proceeding was orchestrated to eliminate Trump from the presidential race. Some supporters are calling for mass demonstrations outside the Alexandria detention facility. Things escalated further when Trump's campaign released a statement hours after the detention order, calling Judge Chutkan's ruling an unprecedented assault on democracy and political speech. The statement characterized the detention as communist-style political imprisonment designed to silence Trump and prevent him from exposing corruption in the Biden administration. It called on supporters to donate to Trump's legal defense fund and to vote in overwhelming numbers to overcome what it termed a rigged system. Stay with me. What comes next will completely change your understanding of this judicial crisis. Here's what makes this situation even more constitutionally fraught. Trump's detention raises novel questions about how a detained defendant conducts a presidential campaign. The Federal Election Commission has no precedent for regulating campaigns when the candidate is in federal detention. Questions arise about whether Trump can participate in debates remotely, whether his detention facility access to media constitutes an unfair advantage or disadvantage, and whether restrictions on his communications violate his political speech rights. Constitutional scholars are grappling with the intersection of criminal detention and presidential campaigns. Professor Michael Dorf of Cornell Law School told reporters that while the detention appears legally justified based on witness protection concerns, it creates unprecedented scenarios regarding Trump's ability to participate in democratic processes. Dorf noted that the Constitution contains no provision prohibiting detained individuals from running for or winning the presidency, creating the theoretical possibility of a detained presidential candidate. This goes far beyond Trump's legal predicament. It addresses whether the American judicial system maintains its fundamental authority to protect witnesses and ensure fair trials when defendants hold significant political power and public platforms. If courts cannot detain defendants who systematically intimidate witnesses simply because those defendants are politically prominent, then political status effectively places some Americans above the procedural rules that govern criminal proceedings. If this blows your mind, hit that like button right now. Here's the crucial principle at stake. Bail in the federal system serves two purposes: ensuring the defendant appears at trial and protecting the community and the integrity of judicial proceedings. When defendants demonstrate through their conduct that they pose a danger to witnesses or will obstruct justice if released, courts must detain them regardless of their wealth, prominence, or political status. This principle applies equally to all defendants. The implications for Trump's campaign and legal strategy are devastating. His entire approach has relied on using his platform to maintain public support, attack prosecutors and witnesses, and frame the prosecutions as political persecution. Detention removes his ability to communicate directly with supporters through rallies and immediate social media posts. His legal team must now prepare for trial without his active involvement in strategy sessions and public messaging. Keep close watch on this rapidly developing crisis. Trump's attorneys are expected to file emergency appeals to the D.C. Circuit and potentially the Supreme Court, seeking immediate release pending trial. The prosecution will file responses arguing that Judge Chutkan's factual findings support the detention order and that Trump's own conduct created this situation. And the Alexandria detention facility is preparing for unprecedented security and logistical challenges associated with housing a former president. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge has revoked Trump's bail and ordered him detained in federal custody after finding he systematically violated release conditions by intimidating witnesses. U.S. Marshals have executed the detention order. Trump is being held at a federal facility in Alexandria, Virginia, pending his March 4th trial date. His presidential campaign faces unprecedented disruption, with the candidate unable to appear publicly or communicate directly with supporters. This isn't a temporary setback that will be quickly reversed on appeal. This is a federal judge making detailed factual findings that Trump poses a clear and present danger to witness safety and judicial integrity. Appellate courts rarely overturn such determinations when supported by extensive evidence. Trump faces the very real possibility of remaining in detention through his trial, conducting his presidential campaign from a federal facility, and facing voters while held on charges of election interference. The constitutional and political implications are staggering. America has never confronted a scenario where a major party presidential candidate campaigns from detention. The legal questions about witness protection, First Amendment rights, and the intersection of criminal proceedings with political campaigns are unprecedented. And the fundamental principle that no American stands above the law faces its most direct test in a generation. The stakes could not be higher. Trump's detention will either vindicate the principle that the judicial system can protect witnesses and ensure fair proceedings regardless of a defendant's political power, or it will fracture public faith in the courts and create a constitutional crisis around competing claims of legal authority and political persecution. What happens in the coming days and weeks will shape American democracy and the relationship between political power and legal accountability for decades to come. The detention is immediate and real. The appeals will determine whether it continues. And the American people must grapple with the unprecedented reality of a presidential candidate conducting his campaign from federal custody while facing criminal charges that could result in decades of imprisonment. Pause for a second and hit that like button if you're finding value in this coverage. The trial that will determine Trump's future and test the limits of judicial authority over political figures begins in 6 weeks.